Good evening. I'm Marcy Kahn. I'm chair of the Rule of Law Task Force here at City Bar, and I'm delighted to welcome you this evening to our program on the need for a special tribunal on the crime of aggression in Ukraine. The importance of this topic to us here in the United States could not be more obvious, as each day's news reports of the horrific war crimes conducted against the people of Ukraine makes clear. But how are justice and accountability for the crime of aggression, the crime of starting the war in the first place with the cascading decimation of the country which has followed, to be accomplished? As of now, that is an open question. Tonight, we are most fortunate to have with us an extraordinary group of speakers who have been studying this question and working tirelessly toward its resolution. I offer the thanks of the Rule of Law Task Force to the leaders of the 10 other Bar Association co-sponsoring groups for their support of this evening's program, and my thanks to our program chair, Professor Jennifer Trahan, whom you'll hear from tonight, for her vision and development of the program, and our subcommittee member, Milana Bretgoltz, for putting this program together. We're thrilled to have as our moderator this evening Professor Ona Hathaway, Professor of International Law at Yale Law School and Director of its Center for Global Legal Challenges, among her other pursuits. Professor Hathaway has written and lectured extensively on the creation of a special tribunal for the crime of aggression in Ukraine. She will be introducing our other speakers, all of whom will be glad to take your questions at the conclusion of all of the presentations. The only exception to that is the Ukrainian ambassador, the Honorable Anton Koronevich, whose keynote remarks were pre-recorded due to the time difference with Ukraine. Professor Hathaway, the floor is yours.
Thank you so much, and thank you to all of you for being here today and spending your evening with us to talk about this important set of issues. Here's the plan for the evening. I will give a bit of background because I don't know that everyone here is sort of schooled in the details of the crime of aggression, and I thought it might be helpful to sort of back up a little bit and explain kind of how do we get to this question of the creation of the Special Tribunal to try the crime of aggression. Then I'm going to be putting a series of questions to our panelists, and I'll introduce them as I turn to them, because I think their introductions will make clear kind of what their expertise is and why the question is the right one to put to them. And then we're going to have a closing with Ambassador Tamasar, who will explain to us his views on the importance of this issue. So that's the plan for the evening. Okay, so first question that some of you may be wondering is what exactly is the crime of aggression? And by crime of aggression, what we mean is the crime of waging an illegal aggressive war. So by contrast, a war crime, which is also happening in Ukraine, is the crime of waging war in the wrong way. So for example, a war crime is a crime, it's a war crime for Russian soldiers to intentionally bomb a school or a hospital or intentionally target civilians of any kind. But it's not a war crime for Russian soldiers to kill Ukrainian soldiers in combat. It's not a war crime for Russian missiles to destroy a Ukrainian military base. It's not a war crime for Russia to try to kill Ukrainian President Zelensky, which they have tried many times unsuccessfully, luckily. And while civilians cannot be targeted, it's not a war crime to kill them as long as their deaths are proportionate to the military purpose. And if so, then they are legal collateral damage. But all of these deaths are the result of an illegal war. And that's why the crime of aggression is filling this really important gap that's left, even though we can prosecute war crimes. Right? So that's why the issue is such an important one today. Now, for most of history, there was no such thing as a crime of aggression because war was perfectly legal. Indeed, war was a main way in which states resolved their legal disputes that they couldn't resolve peacefully. That only really changed in 1928 when nearly every country in the world joined the Calabrian Treaty, which for the first time outlawed war. Now, the first court with jurisdiction to try the crime of aggression was the International Military Tribunal established at Nuremberg, Germany. That's famously the trial at which the Holocaust crimes were charged. But it was also the first trial at which the crime of aggression was charged. And in fact, the crime of aggression was essential to getting that court up and running in the first place. Now, the prosecutions there filed against 24 Nazi leaders of World War II were for what was then called the crime against peace. And that was for their actions specifically in violation of the Calabrian Pact, that is, launching an illegal war in violation of the pact. And in its judgment, finding several of the defendants guilty, the Nuremberg court explained the foundational importance of the crime. It said, to initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from the other war crimes, and that it contains within itself the accumulated evil of the whole. So today, crime of aggression is not defined by reference to the Calabrian Pact any longer. It's defined in reference to the United Nations Charter. The Charter, created at the close of World War II to maintain and sustain international peace, places the prohibition on the use of force at its core. So Article 2.4 of the United Nations Charter reads, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. Now, while this prohibition has certainly not been perfectly observed, it's contributed to an extraordinary reduction of interstate wars in the post-war era, has made conquest of territory, which was once very common, exceedingly rare, and it's enabled trade and growth throughout the globe without fear that gains will simply become the spoils of war. Now, Russia's war in Ukraine has put all of that at risk. When Putin launched a war against Ukraine nearly a year ago, he began the largest cross-border land war in Europe since World War II. And now this, of course, follows on the illegal annexation of Crimea by Russia in 2014, the first conquest of territory in Europe since World War II. Russia's invasion of Ukraine, aided by Belarus, does not just represent a blatant violation of a rule of international law. It represents a threat to the foundational principle that underpins the modern legal order. Now, just briefly, why do we need a special court here? As you may have heard, the International Criminal Court is already investigating war crimes in Ukraine and has already got jurisdiction to investigate crimes taking place in the course of this war. So why do we need another court? Well, the International Criminal Court is the first court since Nuremberg created to try the crime of aggression. It has jurisdiction over the crime of aggression. And the treaty that created it is known as the Rome Statute. You're probably going to hear that thrown around a few times today. And that granted jurisdiction over the crime of aggression. But unlike the other crimes, the crime was not defined in the initial treaty. That was left to a conference of states that had ratified the treaty held in Kampala, Uganda in 2010, which Ambassador Venevesor was a key figure. At that conference, the states agreed to limit jurisdiction over the crime only to states that had become parties to the court and had accepted the amendments. So while the other three crimes in the statute, that is the treaty that creates the court, crimes against humanity, war crimes, and genocide, can be brought against a state that is a party to the statute or that committed its crime in the territory of a state that's accepted the jurisdiction of the court. That's not true of the crime of aggression. So for the crime of aggression, the International Criminal Court only has jurisdiction if the crime is committed by a state that has agreed to the Rome Statute and has accepted the amendments. Now, of course, Russia has not agreed to the Rome Statute. It signed but never ratified the Rome Statute. Belarus, similarly, is not a party to the Rome Statute, and therefore, the crime cannot be charged against Russians for the crimes that they're committing on the soil of Ukraine, even though the other three crimes can be charged. Right, so that's the difference in the Rome Statute. It leaves this big gap for jurisdiction over the crime of aggression, even though the International Criminal Court can investigate the other three crimes that are being committed in Ukraine. So that's why we are here today. That's why if there is going to be liability in an international court for the crime of aggression, we need a special Tribunal to try the crime of aggression. So hopefully that's helpful background. Now, before we turn to the panelists who are here, we're lucky to have recorded remarks that were made specially for this event by Ambassador Anton Kontorovich. He's a Ukrainian lawyer specializing in public international law, international humanitarian and international criminal law. He's been ambassador at large in the Ministry of Foreign Affairs of Ukraine since May 25th, 2022. He's coordinating the issue of the establishment of the Special International Tribunal for the crime of aggression against Ukraine on the Ukrainian side. So he's really the person in the Ukrainian government working hard on this issue, and he recorded some remarks for us here because it's, of course, much too late in Ukraine for him to participate in this event live. So we have those remarks for you, and then we're going to turn to questions for the panelists.
Dear colleagues, it's a pleasure and honor to talk today to you and to all the participants of today's important event. As you know, the issue of accountability is one of the key importance issues for Ukraine nowadays. Inside the peace formula by the President of Ukraine, Volodymyr Zelensky, accountability is mentioned as one of the key priorities. And as we say, there may be no peace without justice, and there may be no peace without accountability. So that is why when we talk about peace, we talk that in order to reach peace, to gain peace, we need to secure justice and accountability. And in order to secure justice and accountability, we need to ensure that the comprehensive accountability system is taking place, that there is not a single element which goes with impunity, and that all the perpetrators of the most serious crimes under international law committed in the territory of Ukraine are brought to responsibility. That saying, we as Ukrainian government have filed the lawsuits, the applications to all the possible international courts and tribunals since 2014. We are in all the courts: International Court of Justice, European Court of Human Rights, International Tribunal for the Law of the Sea, arbitrations under the PCA and arbitrations under the United Nations Convention on the Law of the Sea, private, public, so private to sovereign subject investment arbitrations. We are in all the courts. We also recognize the jurisdiction of the ICC, and now the Office of the Prosecutor of the International Criminal Court does conduct investigation of the situation in Ukraine in relation to alleged war crimes, crimes against humanity, and the crime of genocide. But we see, since we are using all the possible international legal mechanism tools since 2014, we see that these mechanism and tools are not enough, and that impunity is still in, and that we need to close gaps, loopholes, which exist in the current architecture of international, in particular criminal justice. With this saying, we say that there are two main loopholes, gaps, which we need to close. The first is the accountability for the crime of aggression against Ukraine. And the second is the establishment of a comprehensive compensation mechanism with international register of damage. Today, we will, of course, mostly talk about the first one. So we see that the accountability for the crime of aggression against Ukraine really must be ensured, and this is a real gap which now exists in today's contemporary architecture of international criminal justice. There is no international court or tribunal which can try perpetrators of the Russian political and military leadership for the commission of the crime of aggression against Ukraine. The national courts, while doing this, will also face the question of immunities, which will surely arise. So that is why we see that the gap, the loophole really exists. The International Criminal Court, which now, as we mentioned, does have investigation of the situation in Ukraine in relation to alleged war crimes, crimes against humanity, and crime of genocide, cannot exercise jurisdiction over the crime of aggression against Ukraine, since Russia is not a member to the Rome Statute and has not signed and ratified the Kampala amendments on the crime of aggression, and the United Nations Security Council is very unlikely to refer the situation in Ukraine to the International Criminal Court. With this saying, we see that there is really no international court or tribunal which can try perpetrators of the crime of aggression against Ukraine. So that is why we, Ukraine's government, together with our partners throughout the world, together with leading experts, academics, we advocate for the establishment of a special tribunal for the crime of aggression against Ukraine, which will have jurisdiction to try perpetrators of the crime of aggression against Ukraine. And we do this job since the end of February 2022. So it's now almost a year since the idea, the concept, the project of the Special Tribunal for the crime of aggression against Ukraine is being discussed, discovered, and explored in the international community. As of now, we got a serious level of political support to such an endeavor, to such an effort to establish a special tribunal. As of now, we do have 5 resolutions of the European Parliament, in particular the 5th one being a special one dedicated specifically to the establishment of the special tribunal. 6 resolutions of Parliamentary Assembly of the Council of Europe, 2 resolutions of the Parliamentary Assembly of NATO, resolution of Parliamentary Assembly of OSCE, several resolutions of national parliaments of foreign states. We also have a lot of public statements and public positions by leaders of states and governments. So with this said, we see that the question gained serious level of political support. And I think that as of now, there is the understanding in the international community that the accountability for the crime of aggression against Ukraine must be ensured. That if the international community does not respond in this particular case, in this particular situation, to this particular crime of aggression, which is recognized as aggression on the level of all the international organizations, in particular in the resolutions of the United Nations General Assembly resolutions. So this will be a big damage to the international law itself and to the concept of the crime of aggression itself. So I do think that now there is an understanding of a big portion of international community, a big part of international community, that the accountability for the crime of aggression against Ukraine must be ensured. Now the question is not if, but how. So how to do it, how to establish a special tribunal for the crime of aggression against Ukraine in such a way, in such a manner that it is efficient, that it is legitimate, that it is credible, and that it can deliver and can work effectively to get its job done. So that is why, after this year of work, it is very important for us to keep the pace, but also to move closer from these political discussions to legal and technical discussions, for us to see which ways are the most feasible ones and which option and model for the tribunal, which will be the most effective and most feasible for us to establish. So that is why, in particular, why Ukraine gathered a group of states, which we call a core group, which now enumerates more than 20 states, which now also work and had already an in-person meeting in Prague, and continues to work in order to find the legal answers to the key legal questions in relation to the establishment of the special tribunal. We will keep the space and we will do whatever we can in order to actually get the job done. It is also important that on the way to the establishment of the special tribunal, we may have and we will have, because they are needed, some, I would say, real results, real elements or step forwards, in particular on the way to establishment of the special tribunal. And I'm sure you are well aware, you paid attention to the fact that the last week, during the Ukraine-EU summit in Kyiv, the President of the European Commission, Ursula von der Leyen, mentioned that there will be established in The Hague the International Center for the Prosecution of the Crime of Aggression against Ukraine. The International Center, which will work under the auspices of the existing joint investigative team between Ukraine and several EU member states, and also under the auspices of the Eurojust, and will coordinate national investigations of the crime of aggression against Ukraine, which are being done by several members of JIT, of Joint Investigative Team, and which will also gather and secure evidences in relation to the perpetration of the crime of aggression against Ukraine, so that when the Special Tribunal is being established, it can already use the results, the outcomes of the investigations, and the results of the activity of this ICPA. So we look forward to establishing of this center under the JIT and Eurojust in The Hague, and we believe it is a very important step forward in relation to the further establishment of the Special Tribunal. We also believe that the engagement of the United Nations organization is very important, is crucially important for our effort, for our endeavor, because we need our effort to be the most legitimate one, the most credible one, and to get the most wider, broader support possible. So that is why we will use the possibilities of the United Nations, in particular General Assembly, in order to sound this issue and in order to get the support of the United Nations in relation to this endeavor. Finally, I would say that in the end of December 2022, President Volodymyr Zelensky gathered Ukrainian ambassadors abroad in Kyiv and put them tasks, assignments for the year 2023. And one of the main assignments for the year 2023 for the Ukrainian diplomacy is the establishment of the Special Tribunal for the crime of aggression against Ukraine, and keeping the pace on this track. So with all that said, we will continue our job, our work, together with partners, a lot of whom are today present on this important event. And we are sure that together we will find all the solutions and all the answers. And finally, we will do our job. And the Special Tribunal for the crime of aggression against Ukraine will be established. It is important not only for Ukraine and not only for accountability and justice in our country. It is important for contemporary modern international law and the very concept of the crime of aggression as a whole. I thank you.
Great. So now what I'd like to do is turn to the panelists who are here, and then we also have a panelist who is joining us remotely, and I'll introduce them as we go. So first, I want to start with Ambassador Christian Veneweser. Ambassador Veneweser is Liechtenstein's permanent representative to the United Nations. He has extensive experience on the crime of aggression. He presided over the Kampala conference that I mentioned in 2010, which adopted the crime of aggression amendments to the Rome Statute. Prior to that, he also chaired the Special Working Group on the crime of aggression, which negotiated the definition of the crime of aggression for nearly a decade with the participation of all UN member states. So he's been working on this intensively and has really been a key force behind this effort to design and make a case for a special tribunal for the crime of aggression. So Ambassador, can you just walk us through your perspective on why is an international tribunal needed? How does this look from the perspective of somebody who's viewing this at the UN?
Thank you so much, Ona, and I want to thank everybody for coming this evening and for the American Bar Association for hosting us. It's a pleasure to be here. You know, in response to your question, Ona, why is it necessary? It's necessary to establish a special tribunal because otherwise this crime will not be prosecuted because nobody else can do it. So we would be very happy if the International Criminal Court could do it, but it cannot. It does not have jurisdiction in this case. Now, of course, people will say, yeah, but it has jurisdiction over war crimes and over crimes against humanity and over genocide. Is that not enough? And in our view, it is not enough, because if there was no war in Ukraine, if the decision had not been made to invade the country, all these other crimes would not be happening today. So, you know, the evidence, of course, of war crimes is overwhelming. You can see it on your TV screens, and you know, none of this is an accident. I think in every armed conflict there are violations of the Geneva Conventions. There are always war crimes, but what you see unfolding in Ukraine is the continuation of a playbook that you have seen before applied in Syria and before that in Chechnya. Mariupol looks like Aleppo and looks like Grozny. So this is, you know, these are not war crimes that happen. This is systematic warfare in a blatant violation of international humanitarian law. But again, the point here is for us, what is the crime? What is the origin of the crime? And the crime is the war itself. And everything else is a result of that. So the manner in which the war is conducted, the manner in which the civilian population is attacked is a result of the war itself. So that is for us the first point that has a lot to do with Ukraine itself and with this conflict itself. The second point goes beyond that, and it goes to what Anton has talked about when he mentioned, I think the words he used was the contemporary legal order. You know, the United Nations was created to prevent war. And the way that was done was to regulate the legality of the use of force. So the UN Charter says, in essence, there are two instances in which it is legal to use force for a state against another state. And the first instance is if the Security Council authorizes you to do so. And the second is if you defend yourself, as Ukraine is doing in this conflict. In all other circumstances, the use of force is illegal. And that's the system created in 1945. So in a way, war has been illegal as a foreign policy tool since the creation of the UN, and of course, as you have said, since 1928 before. There was a time when war was not illegal, but now it is. In 1974, the General Assembly of the United Nations has defined what aggression is by consensus. It has defined a list of acts that qualify as aggression. So since 1974, we have all agreed what it in fact is, what it means to conduct an illegal war. And since 2010, we have known what the crime of aggression is. That means not what the act of the state is, but what is the crime that an individual, a person, the criminal act by a person, what is that act by a person that qualifies as a crime of aggression? And that we have defined in 2010, and that was not defined, you know, by the Estonians and us and some others who agreed. It was defined by everybody in a negotiation open to all states in which the Russian Federation participated, China participated, and many others who have not subscribed to the law afterwards. So that is the law that we have given ourselves. And we strongly believe that this is a defining moment to defend this international order. And we can only do that by holding those criminally accountable who have made the decision to initiate this war. And that's a very important feature of the crime of aggression, because if you roll your tank across the border from Belarus into Ukraine, you do not commit the crime of aggression. If you fly your airplane into Ukrainian territory, you do not commit the crime of aggression. You only do that if you are a person in a leadership position, be it military or political, in that country. And it seems to us very clearly that the fact that this is a leadership crime is evidenced in this particular case very strongly. And of course, we have also here, and I think that's extremely important, a situation where, you know, it's not my view that this is aggression, or Ona's view, or David Scheffer's view, or Anton's view. It's the view of the international community. The General Assembly of the United Nations has said this is an act of aggression on repeated occasions. The very body itself that has defined what aggression is has said this is aggression, and I strongly believe that that's the basis that we need to act on. Thank you.
Great. Thank you so much for that very helpful answer. I want to turn now to David Sheffer, so if we could bring him up on screen. He's our kind of ghostly presence right now. There he is. Okay. So David is a senior fellow at the Council on Foreign Relations, and during the second term of the Clinton administration, David was the first U.S. ambassador at large for war crimes issues and led the U.S. delegation to the UN talks establishing the International Criminal Court. He signed the Rome Statute of the International Criminal Court on behalf of the United States, and he negotiated the creation of 5 war crimes tribunals: the International Criminal Tribunal for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, the Extraordinary Chambers and the Courts of Cambodia, and, as mentioned, the ICC. So David, with all this experience, as I just mentioned, you've been involved in setting up an international criminal court many times in the past. Can you say a bit about how this would happen? And a question that I've heard raised is, do you need Russia to agree? And if not, does the Security Council have to be involved? And does that make that very difficult for reasons that have been mentioned? The Security Council is likely to have any action vetoed by the Russians. So given that, how could this actually happen, given your experience setting up several of these international criminal tribunals?
Thank you, Ona, very, very much. And my greetings to Ambassador Vena-Vesar and everyone else. I just want to say, since this is the New York Bar Association, I've been a very proud New York lawyer since 1979 and will continue to be. So it's always a great pleasure to speak before the New York Bar Association. We have been here before and we have not been here before. That is the basic principle of building an international or hybrid criminal tribunal to prosecute atrocity crimes, namely genocide, war crimes, crimes against humanity, and aggression. We have been here before because during the 1990s, a particular procedure was followed in the creation of the Extraordinary Chambers in the Courts of Cambodia, whereby the UN General Assembly adopted a resolution directing the Secretary General of the UN to negotiate a treaty between the United Nations, which has legal personality and enters into treaties all the time, with the government of Cambodia to build a criminal tribunal to prosecute the surviving leaders of the Khmer Rouge, which under Pol Pot ravaged Cambodia in the late 1970s. That negotiation took place. A treaty was concluded, a domestic law in Cambodia was adopted, and what resulted from it was, yes, a Cambodian criminal court, in other words, one under Cambodian law, but it also was a joint venture court between Cambodia and the United Nations, because under the treaty that was negotiated and became binding on both the government of Cambodia and the United Nations, there would be an enormous infusion of UN staff, prosecutors, judges, investigators, administrators, and very much financing in order to enable the Cambodian tribunal to do the job it needed to do, which was not really to prosecute domestic Cambodian law, which did have a role in the statute. There are components of it there. But the major components of the statute of the Cambodia Tribunal were international, that had already been negotiated for the Yugoslav and Rwanda tribunals, for the Special Court for Sierra Leone, and of course for the International Criminal Court. So that was an instance where the General Assembly, and I really would persuade everyone to take seriously Ambassador Vena-Vesar's point about the General Assembly as speaking for the international community in this respect. This really was a court that responded to that international character, to that international focus and purpose. And it sustained the support of the General Assembly for 20 years thereafter in order to complete its mission. The difference, however, is that it was literally a domestic Cambodian court. So when I say we've been there, but we haven't been there, is that what we have been arguing among our group that is presenting this evening, the position we've been putting forward, is that the General Assembly certainly has the authority to do exactly what it did in creating the Cambodia Tribunal. However, it has the authority to move one step further, which is to say that the treaty negotiated between Ukraine and the General Assembly would be for the purpose of establishing an international tribunal, not one in Kyiv, but one probably situated in The Hague with the consent, full sovereign consent of the Ukrainian government to pursue this on an international basis. Now, that is precisely what happened in the creation of the Special Court for Sierra Leone. It was created as an international tribunal, but it was done through a resolution of the Security Council directing the Secretary General to create that court by treaty. But it was not a Chapter 7 mandatory enforcement resolution. And of course, neither would be the UN General Assembly one. I think I would want to just stress that in the building of these tribunals, I find over 30 years that one is always confronted with, shall we say, the very highly educated, cynical position, which I respect, but which also is sort of historically static, which is, oh my goodness, we haven't done this before precisely this way, and therefore it must not be possible to do it. And, you know, I worked for 18 years with Madeleine Albright. She was my boss during the Clinton administration. And that's the very last thing Madeleine would ever follow in her life. I certainly learned at the feet of the master that when you need to get things done, you work innovatively. You obviously work within the law, but the law evolves. It evolves through procedural process, which is in the hands of men and women who act properly within their institutional formats to move forward. And that's, I mean, when Madeleine suggested building the Yugoslav War Crimes Tribunal in February of 1993, just within days of taking office as our ambassador to the United Nations, a lot of people said, what? Well, that's impossible. The Security Council cannot build a criminal tribunal. And our response to that was, I'm sorry, there's nothing prohibiting that in the UN Charter. Please show me where it's prohibited. And please tell me that this is not a step towards addressing international peace and security issues, which are within the jurisdiction of the Security Council. And also, quite frankly, within the jurisdiction of the General Assembly, not in terms of passing mandatory resolutions, but still taking the issue up, whether it be under the Uniting for Peace resolution or otherwise. The General Assembly is not immune from discussing these issues and passing resolutions that it wishes to. I would close with this, for those who are in the sort of cynical, legalistic field of examining this proposal, which is that, as I say, there's nothing prohibiting the General Assembly from doing this, but also a General Assembly tribunal of this character, it's not a General Assembly one, it would be between Ukraine and the UN, would not have the authority to force any government to cooperate with it, because it's not a Security Council subsidiary body like the Yugoslav and Rwanda tribunals. Everyone knows that, we get it. It's not that every government has to, or it's mandatorily has to comply with this tribunal, but actually in reality, a heck of a lot would, and that's what makes the difference. And I leave to my good colleagues the whole issue of dealing with personal immunities, et cetera, and the advantage of this. But I just want to close by saying that this is imminently possible. It's not an impossible or improbable or legally highly suspect procedure. It is following procedure. But it also, just like Justice Jackson said going to Nuremberg, he wrote a memo to President Truman saying, sir, I'm going to Nuremberg. We're actually going to create some international law at Nuremberg. It's not that it is law, we will have to create some law. And he did so, and he did so successfully. And I think at the same time, it can be done in this procedure as well. Ona?
That was fantastic. Thank you so much, David, and a really great perspective for those of us who are launching on this endeavor for the first time. That we've been here before, in a sense. The skepticism is not new. So I want to turn to my colleague here, Jennifer Trahan, who is a professor at NYU Center for Global Affairs. She's also convener of the Global Institute for Prevention of Aggression and the author of numerous writings on the crime of aggression, as well as abuse of the veto power by permanent members of the UN Security Council. So Jennifer, one question that's come up repeatedly in the discussion about a possible special tribunal is whether it's possible to get the top leadership of Russia in front of a court. Can you get Putin is the short version of it. Pretty much every reporter I talk to, that's their first question. So can you speak a bit to that? And to get a little bit more technical, because this is relevant, how do immunities factor in here? So there's immunities that apply to certain top leaders. So how do we get around those immunities?
Super. Thank you, Ona. And first, let me say what a great pleasure it is to appear on this panel. Thank you particularly to Marcy Khan for having the task force on the rule of law put on this program at the New York City Bar Association. So we here are talking about the best model of tribunal, and there are very starkly divergent visions being put forth right now. And what those of us, Professor Hathaway, Ambassador Van der Weser, David Scheffer, and I, as well as some colleagues we've had the pleasure of working with, Klaus Kress, a judge on the ICJ, Astrid Reisinger-Corsini of the University of Vienna, what we're proposing is an international tribunal. You could also create a tribunal within the Ukrainian legal system, yet there are a whole host of reasons why this would produce a weaker tribunal, and we don't want to go in that route. Ambassador Scheffer has laid out how this would happen. It would be an amalgamation of the process that created the Sierra Leone Special Court and the Cambodia Tribunal. So this has been done. It just needs kind of amalgamating those two procedures. So the process is fairly straightforward. Ukraine would request the tribunal. The General Assembly would have to recommend the negotiations. These would then occur between the UN and Ukraine and result in a bilateral treaty. This would create an international tribunal. One of the reasons we want an international tribunal is it doesn't have immunities problems. What do I mean by this? Well, it's the immunity, the personal immunity of the sitting head of state, sitting head of government, and sitting minister of foreign affairs. These individuals could not be prosecuted, let's say, if we had a national endeavor. Or anything short of an international endeavor. So Ambassador Van der Weser mentioned this is a leadership crime. So in our definition, that took 10 years to negotiate with all states invited, as was explained. If you want to look at the definition, it's Article 8 bis of the International Criminal Court's Rome Statute, and it says the crime is a leadership crime in that it is committed only by those in a position effectively to exercise control over or to direct the political or military action of a state. So the reason for this is ordinary soldiers do not make the decision to go to war. Mid-level commanders do not make the decision. It is only made at the very highest levels. So if we're going to prosecute the crime of aggression, you want to go to the leaders, and the only way we can do this soundly is an international tribunal. Why? Well, this derives, there's a Latin saying, par in parem non habet imperium. It's basically a sovereign doesn't sit in judgment over another sovereign. This came up in the International Court of Justice's Eurodia, aka arrest warrant case 2002, and there they held that a Congolese minister of foreign affairs was immune for proceedings before a Belgian court, even for international crimes. But they said that would not be true of an international tribunal. Then we have this applied, the 2004 case of the Sierra Leone Special Court. It was looking at the arrest warrant against Charles Taylor. So charges were pressed when he was still the sitting head of state. I know he was tried once an ex-head of state, but he was charged when a sitting head of state, and the challenge came when he was a sitting head of state. And the Sierra Leone Special Court Appeals Chamber in 2004 ruled, using the Eurodia precedent, that someone indicted before an international tribunal could be tried, even the sitting leadership. And as Professor Astrid Reisinger-Corassini and I set forth in a blog post on Just Security, the distinction in these tribunals is really an international tribunal created by international means, and it needs to represent the will of the international community. And the tribunal we're proposing would meet these criteria. We thirdly have the Bashir case. This was Jordan's failure to arrest then President Bashir when he traveled to the territory. Of course, he's wanted on charges before the International Criminal Court, including for genocide. Jordan, a state party to the Rome Statute, did not arrest him. This became a case, and the International Criminal Court Appeals Chamber unanimously ruled there is neither state practice nor opinio juris that would support the existence of head of state immunity under customary international law vis-a-vis an international court. So that's why we're making much of this distinction. The other possibility, we can sit and wait around until Putin is an ex-head of state, or other senior Russian military leaders are all out of office, and then we don't have to worry about immunities, but we have no idea when that might be. Finally, I just want to note, others, as some on the blogosphere have critiqued us, why are you so worried about, 3 positions? And I would say, well, it's not 3 highest Russian positions only. It would be the same for Belarus, which has allowed its territory to be used as a staging ground for the invasion. And that's clearly picked up in the General Assembly's definition of the crime, and therefore the Rome Statute, a bis definition of the crime. So we're talking at least 6 of the highest level leaders. And in one tweet responding to, why are you so worried about this? A friend, some may know Kip Hale, he said, it's as if at Nuremberg you didn't prosecute Hitler, where he's still alive at the time of the Nuremberg trial. So I think I'll rest with that. That's why we're pushing for an international tribunal created going through the UN system after a vote by the General Assembly. The Security Council is paralyzed. It has created past tribunals, Yugoslav and Rwanda tribunals, but it obviously can't act in this situation. So the body that can act, and all it needs to do is make a recommendation for the commencement of negotiations, and Ambassador Scheffer, who has set up numerous of these tribunals, knows that this is a potential, this is quite a possible process. Not only possible, it's quite a sound process for doing this. So we have a clear path for doing this that avoids head of state immunity. So we need to pursue this. Thanks.
Thank you. So I'm going to go back to a couple additional questions, but we are going to reserve about a half an hour for questions from all of you. So I hope you're all thinking of questions so we can turn to you for questions in a few minutes. So first I want to return to you, Ambassador Venneveser. What about the longer term? Some have worried that creating a special court means selective justice, and it doesn't really solve the long-term problems. So we're creating this court to deal with this particular problem. But, is this really going to solve the longer term issue of the crime of aggression to create a special court? And what about concerns that sort of we're creating a court here, but there hasn't been a special court created in other instances? So how would you respond to those concerns?
Thank you, Ona. First, maybe to just quickly agree with, I think the way David in particular has talked about this, this is not ultimately a legal problem. I think he did say it's eminently possible. He mentioned Nuremberg, and there was actually much less law going into Nuremberg than there is going into this. So the law is there. It's really a question of whether you want to do it. So I think that needs to be very clear. I'm not saying there are no legal issues to be addressed, but they can totally be addressed. And the main issue to be addressed is immunities, because aggression is a leadership crime. And I don't want to be the person that has to explain why it's good to create a special tribunal, but you cannot prosecute the people who have committed the crime, because that's what it comes down to. So immunities need to be addressed, and this is why an international tribunal is necessary. Now, to go to your question, Ona, it does not address the long term, but it is an indispensable step to address the long term. So in our view, the jurisdiction of the ICC over the crime of aggression, that is so limited so far and so narrow that it cannot have the law applied in this case, needs to be changed, and it needs to be brought in line with the jurisdiction that the ICC has over all the other crimes. And really is that simple. And, you know, people in this room who have been part of this process for a long time have felt this way for a long time. We had to make compromises in Kampala that we were not happy about in this respect, and here is the moment to change the law. Because here is the moment that we have to say, well, this is what is needed. The ICC has jurisdiction over 4 crimes. They are the international crimes, and they are of equal importance, so the jurisdiction should be the same. So that is the solution for the long term. It's simple and it's difficult, but it is simple, and that is, in our view, what needs to be done. What happens, though, if we don't do this? And that's why I said it's an indispensable step. If we do not prosecute this crime in this instance, that sends the message that this is a crime that will not be prosecuted in the future. If you can do this against the pronouncement of the international community, the message is this crime will not be prosecuted, not before the ICC, not before a special tribunal, not anywhere. And that is why we need to do this. And this is also why this is, in fact, a measure to strengthen the International Criminal Court and not to undermine it, as the prosecutor seems to believe. Thank you.
Great. Thank you for that. So I want to turn back to you, Jennifer, briefly. So you mentioned this a bit already in your discussion about immunities, and one of the advantages of an international court vis-a-vis a hybrid court created within the Ukrainian system is that immunities wouldn't apply. But I wanted to invite you to say a bit more about the hybrid court. So this is another proposal that's sort of on the table. So one proposal is a proposal that is a so-called Yale plan, which those up here have endorsed, or I think everyone up here has endorsed, which is the proposal to create a special tribunal through the process of a recommendation from the General Assembly that would then lead to a negotiated agreement between the United Nations and Ukraine. There's another proposal that's on the table, which is the idea of creating a hybrid court. The version that has kind of gained steam is a hybrid court that would be created within the Ukrainian legal system. At least a few European states have endorsed this approach. Can you say a little bit about what are the differences between these two and why you think the international court, so obviously immunities is one we've already talked about, but what are some other reasons that we might favor an international court vis-a-vis a hybrid approach?
Super, thanks, Ona. And just to maybe echo on one sentence to Ambassador Venevezer's last remarks, we do envision this as a 2-step process, that an ad hoc solution now and fixing the Rome Statute's jurisdiction. We've gotten where we are on having to deal with an ad hoc process because the Rome Statute has such a truncated jurisdictional provision only on the crime of aggression, much more expansive jurisdiction on genocide, war crimes, crimes against humanity. 2 very different jurisdictional regimes. As I see Parliamentarians for Global Action in the audience, I know that they were the first out saying we need to fix the Rome Statute's jurisdiction. A group I convene, the Global Institute for the Prevention of Aggression, and I see some of its members here as well, has also endorsed this, that we need to, for the long run, fix the Rome Statute's jurisdictional provisions. But to your question, the hybrid, and it's a somewhat, and you introduced it very appropriately, it's a difficult distinction. We can have a hybrid tribunal, and hybrid only means it has features of the international system and a national system. You could have a hybrid tribunal that is an international one, such as Sierra Leone Special Court, and very complexly, you could have a hybrid tribunal, such as David referred to the Cambodia Tribunal, in a domestic court system, and that's going to have the problems. And the first one, as mentioned, is immunities. That there are 5 other problems with this approach that has been suggested by some states. The first is it would be unconstitutional under Ukraine's law. And I actually think we could just stop the discussion there. I'm going to go on and do other critiques, of course. But Ukraine's constitution in Article 125 said the establishment of extraordinary and special courts shall not be permitted. And a hybrid tribunal would be such an extraordinary or special court. Now, Ukraine's constitution cannot be amended under a state of emergency, and Ukraine's under a state of emergency. So we have to deal within the framework of Ukraine's constitution. As Professor Hathaway and Ukrainian lawyer Alexander Komarov have explained in a blog post on the Just Security series, Ukraine's constitution basically prohibits forming a hybrid tribunal within the Ukrainian system. As mentioned, I think we could just stop here with that proposal. I'm going to continue a little bit more. If we go solely down the Ukrainian route, we are probably giving complete impunity to the leaders of Belarus. So they, as of yet, we're not aware that they're implicated in any war crimes or crimes against humanity, so they're potentially not being examined by the International Criminal Court. If they're not examined for the crime of aggression, then they go completely scot-free. Secondly, the judgments of a tribunal within the Ukrainian system are not going to have the same weight as the judgments of an international tribunal. You could have the most skillful and fair Ukrainian jurists, but they will easily be the target of a propaganda campaign saying they can't be fair. And it would be difficult because all of the Ukrainian people are suffering from this war. Questions might additionally be leveled because Ukrainian laws allow trials in absentia. So if we have aggression trials in absentia, even more questions will be raised. They simply will not be seen to be impartial, and the judgments of Ukrainian tribunals, in the circumstances, Ukraine as the victim of this invasion, they are not going to have the authoritative weight that we need when we need to enforce the UN Charter and the basic stability of the borders of all states. We need a solid precedent. Fifth, Ukrainian arrest warrants are likely not going to have the same precedential weight as warrants by an international tribunal. Now, I know international tribunals have had their difficulties getting arrest warrants executed, so the International Criminal Court has struggled with some outstanding arrest warrants, but arrest warrants by a single state are going to have less weight. And particularly if the special tribunal is formed through the UN system, we would hope that states voting in favor and maybe the states contributing in funding the tribunal will feel some sense of ownership and make sure arrest warrants are executed. As David mentioned, forming the special tribunal by bilateral treaty between the UN and Ukraine means it could only technically impose cooperation obligations on Ukraine, not third states who are not parties to the treaty, but yet third states actually could join through voluntary cooperation obligations, voluntary cooperation agreements, and legal obligations to cooperate. Six, Ukrainian law has insufficient sentences for the crime of aggression. Under Ukraine's criminal code in Article 437, the crime carries a 7 to 15 years sentencing range. That's an extremely short sentence. As Ambassador Veneveser quoted from the Nuremberg judgment that aggression is the supreme crime, this formulation is used because not only absent the aggression would there be no war crimes or crimes against humanity, there would be no fatalities. There would be no property damage, cultural heritage destruction. There also wouldn't be the deaths of Ukrainian soldiers or Russian soldiers. There wouldn't be famine caused from blocked grain shipments. All of the harms flow from this original crime. A 7 to 15-year sentence is not an appropriate sentencing range. So I think it is palpably insufficient for this crime to be prosecuted within the domestic system. A Ukrainian hybrid is really not a sound option when you need to create really solid precedent. This has not been one of these kind of, we sometimes talk about gray area cases, that, you know, the jus ad bellum rules, the legality of going to war, there are some parameters where are questionable. This is not a gray area case. This is a very clear case. It is a flagrant, manifest violation of the UN Charter. If this doesn't get prosecuted, who knows when we'll ever, if ever, prosecute the crime of aggression. And then you have to focus on the potential costs to the stability of this is not an issue just for Europe. This is an issue for the entire international community. It is about the stability of the borders of all states. And that is why we need an international response.
Thanks so much, Jennifer. So I have a last question for David, and then we're going to open it up. And Jennifer's going to take the questions since she's a member of the association. But if you could put David back up on the screen and maybe leave him up for the Q&A session so people remember that he's available for questions as well. David, I know this is something that many people are wondering. Will we ever realistically see Putin or other top Russian leadership in the dock? I mean, we can talk about the creation of this court, but does that seem very realistic? And if not, then what's the point of creating a court like this?
It is certainly realistic, but it's not essential for the purpose of this tribunal. Our experience with the prior tribunals is that there was always great skepticism that heads of state, whether it be in Rwanda or with Liberia relating to Sierra Leone, or with Serbia or the Serbian Bosnian entity within Bosnia-Herzegovina, that these individuals, and frankly also the Cambodia Tribunal, I mean, how would you ever gain custody over some of the top Khmer Rouge leaders hiding in the jungles? Almost all of those were proven wrong, ultimately. The arc of international criminal justice is extremely long. Get set, get ready. This special tribunal might probably be around for 10, 15 years or so, at least. The important thing is that the investigations take place and the indictments are prepared and filed. Now, they can be sealed indictments. If Mr. Putin or Mr. Lavrov are indicted under a sealed indictment and they decide to step outside of Russian territory, anywhere other than Belarus, and possibly the People's Republic of China, they may be subject immediately to an arrest warrant that will be unveiled because the sealed indictment will be unveiled. Even if the indictment is public, it can have tremendous influence. It certainly did with Milosevic. It certainly did with Charles Taylor. It certainly has with al-Bashir in Sudan, who still has not arrived in The Hague. But is he still leading Sudan? No. He's in a jail cell in Khartoum on corruption charges and under the threat that he may be sent to The Hague at any moment. What it does, the indictment, is it essentially delegitimizes the individual, certainly internationally, and then domestically it gnaws away at that person's credibility. And it may take 2, 3, 4, 5 years, 6, 7 years before that individual crumbles. He is tainted, even with his own people, and ultimately they see advantage to frankly removing him from power because they want to get on with it. They want to get on with their lives and the presumed desire for the prosperity of their country. I would also say that there's a very, very strict sanctions regime now in place against Russia. And even if during peace negotiations, if they ever arrive, some of those sanctions might be lifted as a quid pro quo for obviously concessions on the part of the Russian side. Some of those sanctions can stay in place until indicted fugitives of the Special Tribunal or of the International Criminal Court are transferred to the custody of those respective courts. This is a tactic that we used very effectively with Serbia, and the European Union was at the forefront of it to ensure that sanctions would not be lifted and that Serbia would not have any hope whatsoever of joining the European Union someday if Karadzic and Mladic, and certainly earlier than them, Milosevic, were still running around free on Serbian territory. That's just implausible. There's no way Serbia could join the European Union or be part of the European group of democratic nations. So I think there's a possibility of it, but at the end of the day, even if custody is not obtained over Putin and Lavrov and perhaps others that may be indicted, I think the power of the message will be extremely strong. The crime of aggression has been committed. The indictments have been filed, and history will recognize that. I close with this, Ona, that imagine you're a historian 30, 40 years from now, and you're looking back at what we're doing today, what we're doing in 2022 and 2023 with respect to the crime of aggression. How can that historian possibly write that they passed up the prosecution of the crime of aggression in connection with what has happened to Ukraine, the most blatant violation of the crime? It's simply implausible that we would create a system whereby we're inviting historians 30 to 40 years from now from concluding that we not only blew it, but we created a sort of a sanctuary of impunity for those who commit this crime.
Thanks so much for that, David. So I want to just make sure everyone knows that Ambassador Rein Temasar is going to close us out. He's Estonia's representative to the United Nations at the end of the Q&A. So I encourage everyone to stay to hear that. So now I'm turning it over to Jennifer to take your questions.
Thanks. Lots of questions. So we might...
Don't fail to see this side. I can't quite see that side.
So please introduce yourself, say which organization you're from. Please try to pose a question. You can direct it to a particular panelist if you would like to, but you don't have to. I see a hand in the front row. Sorry, do we have a roving mic? Because this is being recorded, or I hope this is being recorded. I think this. So we need to get you on mic. Yeah, thanks.
Hi, everyone. My name is Milana Bretgoltz. I'm a member of the Rule of Law Task Force. First, I want to thank everyone, all the panelists, for a great discussion. I have been working with the Public International Law and Policy Group. Some of you may know it as PILPG. It's a pro bono law firm group, and they have a Ukraine Memorialization and Accountability Initiative. And what we do in the initiative is we interview Ukrainians privately, confidentially, and remotely on things they have seen in Ukraine since the invasion. So they discuss atrocity crimes, crimes of aggression, human rights violations. And the purpose and the objective of the initiative is to document this. So after the interview, lawyers who are trained by PLPG beforehand upload documentation of the interview on a secure portal. And we hope that in the near future, we'll be able to use that documentation to achieve accountability and justice. And so I thought that today would be a great way to sort of advertise the initiative and get people involved. It's a great way to get involved. I found my work very rewarding, and it's very important. And if you're looking for a direct way to get involved, this is a really nice and important way to do it. And so if you're interested, you can contact PILPG via email at pilpg@protonmail.com. Thank you.
Super, thanks for that. I see maybe it would be convenient, we'll just pass the mic over.
Hi, I'm David Nachman, a member of the City Bar Association and a past member of the task force. None of this sounds terribly controversial. So the real issue, it seems, I mean, the only thing that might be controversial down the road is which Russian general is in the leadership group. Okay. I think for the ambassador, I guess the question is, your whole object is to get the greatest consensus and authority of the international community. Where do things stand in the United Nations? And if Russia, China, and India, that represent what percentage of the globe's population, and at least half of Africa, which represents what percentage of the globe's population, are not on board when the General Assembly comes to vote, even if the resolution passes, what will that say about the legitimacy, authority, and to the historians 30 years down the road?
Ambassador Beneviser, I think that was for you.
Yes, very good question. I mean, indeed, the goal has to be to get as many states as possible behind this project, and there's a lot of lobbying that we need to do and a lot of outreach that we need to do. We are happy to do that. We're prepared to do it, and we hope all our partners will. And if that is the case, I think we will have a good result. So if the states that have so far stood united on Ukraine issues do this and go out and explain why this is necessary, then we will have a good result. Absent that, it is difficult, but that is what we are aiming for. And I think, the point that has been made, certainly by me, but Anton mentioned it and others. So this is not just about Ukraine. This is about the rule of law, and this is about the international order. So you are as affected as anyone else is, and that has to be the case that we make.
I don't know if any other panelists want to add on. David Sheffer, you'd have to raise a hand or make a noise, otherwise I won't see you. But absent seeing that, we can go to the front row.
My name is Frank McLaughlin. I'm a member of this organization. I will just mention 2 sentences for the benefit of Ambassador Shepard. I do plead guilty to being cynical, perhaps, and in advance, and I do plead guilty, although not charged, with being somewhat provincial. But I wish the panel would focus a little more on the question of whether or not any special tribunal would have jurisdiction over the subject matter of that which they purport to rule on. I think to equate something to the Nuremberg trials, you must remember we won World War II. So jurisdiction of the subject matter was not an issue, although conceivably it should have been. And perhaps the Allied bombing of Dresden and Leipzig was a war crime too. It was not prosecuted precisely because we won. But if you would focus on jurisdiction of the subject matter, especially in the context of Russia not being a signatory to any of these accords and having the power of veto over any actions of the United Nations, I think you're left with nothing more than moral suasion.
So thanks for that intervention. Maybe I'll initially take a stab at it, and then others can weigh in. David, by all means, go first.
Yeah, with great respect, I strongly disagree. Subject matter jurisdiction.
Why?
The Yugoslav Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, extraordinary chambers in the courts of Cambodia, the International Criminal Court. Now, in none of those cases was there universal participation in those courts. In none of those cases was the subject matter jurisdiction of those courts seriously challenged So we have a tremendous amount of precedence for the subject matter jurisdiction. The real issue that comes up in debate is personal jurisdiction. That's what we spend most of our time debating, whether it be the Special Court for Sierra Leone. The judges had to decide at some point, and they did, whether Charles Taylor could in fact be prosecuted by the court. But they were not raising questions about the subject matter jurisdiction of that court. So I just think that there's a tremendous amount of historical development on the crime of aggression, including the fact that it's now part and parcel of the jurisdiction, the subject matter jurisdiction of the International Criminal Court. It's part and parcel of the General Assembly's own definition of it in 1974 and onwards through all of these resolutions on Ukraine that the General Assembly has pronounced upon. So I just would say respectfully, I don't think the issue is subject matter jurisdiction. That's accomplished. Over the last 30 years, we have nailed to the wall genocide, war crimes, crimes against humanity, and now aggression as proper subject matter jurisdiction for these tribunals. The more difficult question that we're all trying to develop here and respond to is sort of procedurally, how can this tribunal actually achieve jurisdiction over particular individuals? And that really doesn't matter on whether we can achieve custody of them or not. The question is just simply, as a judge might rule, do you have personal jurisdiction over that individual?
You're mixing subject matter with personal jurisdiction. I want you to focus on jurisdiction of the subject matter, which you may have a different definition from that which I have, but subject matter jurisdiction for me is the right to preside and decide this type of case.
So actually, why don't we...
You can't assume it.
Okay, we're not going to have a back and forth here, but let me tackle it a slightly different way by focusing on territorial jurisdiction. The crime of aggression is committed in 2 states. So it's never contained within a single state. One state launches it into another state territory. And it's agreed in all the negotiations that jurisdiction in either the launching state or the receiving state creates jurisdiction over the totality of the crime. This is reinforced by the ICC's decision in the Bangladesh-Myanmar case that all you need is one element of the crime to create jurisdiction over the totality of the crime. So Ukraine being on the receiving end of the aggression creates the territorial jurisdiction. So Ukraine could prosecute it. It can also give away its jurisdiction, or we have an international tribunal created to do this. Where the veto obviously would be a problem if one went to the Security Council. So we're not going to create it as the Yugoslav and Rwanda tribunals were created, but using a different route, the way the Sierra Leone Special Court was created, kind of merged with the Cambodia tribunal process. We need to go through the General Assembly. Or Ukraine could create a tribunal. We just don't believe that is going to be our strongest solution. But I think it makes sense to think of it in terms of the territory. So Ukraine has jurisdiction over the full crime. Russia's not going to agree to the tribunal, okay? So we're not waiting. Russia isn't going to agree to the tribunal, but of course not, right? So our proposal doesn't rest on that. There's a question in the back.
Hi, my name is Nat Dershowitz. I am cynical. I handled a couple of cases from the appeals from the Yugoslavian court, and I think they were disgraceful decisions, if you want my opinion, just in terms of the quality and the thoughtfulness that went into it. They were political decisions using word salad, legal word salad, in order to justify them. Having said that, and letting you know my prejudice, I had some confusion as to the Rome Statute. I had understood it, and I haven't looked at it in 20 years, I admit that. But I thought states had the right to reject the jurisdiction under the Rome Statute itself. And there was a provision in there to amend the statute to include within it crimes of aggression. and you say, how can we have gone so far without having crimes of aggression included? Well, for 25 years now, crimes of aggression were not included within the ICC. And so we did that. And what we seem to be doing now is trying to circumvent the ICC by creating an international court when you couldn't get, the UN couldn't get approval for the ICC to address the questions of aggression. And there's going to be some political feedback on that. Russia, of course, won't accept it. And I'm not even sure. My understanding was the United States didn't sign on to the ICC for many, many years because the fear by Bush and Cheney that they'd be charged with international crimes. So are we now a signatory to the ICC, or are we not a signatory to the ICC?
So I'm happy to address this unless David or Kristen would like to.
I mean, no, the US is not a signatory to the ICC. And David didn't.
Not a party.
They don't have the power. They don't have standing to seek to amend the ICC, am I right?
I mean,
not a signatory.
Okay, I mean, the United States is not a party to the treaty. That is the Rome Statute. It's not a party to the ICC, but it's also not what we're talking about here. I mean, the ICC doesn't have jurisdiction over the crime of aggression committed against Ukraine. It should have it.
It's listed as one of the things that it could be.
It is a crime over which the ICC does have jurisdiction, but not in this particular case. And this is why the proposal is to address this loophole by creating a special tribunal. So the United States is not a party to the Rome Statute, nor is the Russian Federation.
And therefore don't recognize jurisdiction. Correct?
Who are you talking about?
States have.
The United States and Russia do not recognize the jurisdiction of the ICC over those crimes which are part of the jurisdiction of the ICC.
Yep.
Correct.
Well, they have not signed on to the treaty. It doesn't matter whether they recognize the jurisdiction or not, because the ICC does have jurisdiction over the crimes that Russia is committing in Ukraine. Correct.
The other three.
Correct.
So, I mean, but I will just add the U.S. the successor to David, Beth Van Schaack, who's the current ambassador for war crimes, has actually pledged U.S. support and assistance for ICC investigations in Ukraine. So, in fact, the U.S. does recognize the role of Ukraine. But in any case, I think what we... Well,
Investigate Ukraine, but you can't investigate us, the United States.
That's a longer conversation. Yes, that's a longer conversation. And several folks up here would be happy to take that conversation outside of this event. So I think it's time for us to move to our closing remarks from Ambassador Rein Tammissar, who is Estonia's representative to the United Nations. Before his appointment to head Estonia's mission to the UN, Ambassador Tammissar worked at the policy unit of the High Representative of the European Union for Foreign Affairs and Security, and the European Union's delegation in Moscow. From 2015 to 2017, he was a foreign policy advisor to the Prime Minister of Estonia, and more recently in 2018 and 2019, he represented Estonia at the European Union's Political and Security Committee and was Estonia's permanent representative to the European Union. And he's offered to help close us out with some remarks on the importance of the effort to try the crime of aggression.
Thank you. Thank you very much indeed. And thank you very much for New York City Bar Association for organizing this. Fascinating discussion, interesting questions. Maybe for the first time in my life, I regret that I'm not a lawyer, but at least today. So before I'll come to a few of my points, let me say that I have to confess that I believe that we have to establish the Special Tribunal. And not only because my government has decided to support this idea, but also because I'm profoundly convinced that this is the right thing to do from legal, moral, and political point of view. So this is my little introduction to the rather political points that I'm going to make. And I think these political points are framing a little bit this really very interesting discussion. So first of all, let me remind you that what is the main goal of Russia in this endeavor? The main goal of Russia actually is to exterminate Ukrainian nation and to finish off Ukraine as a sovereign country, to erase it from the map. So this is still relevant. This is still what we are trying to pursue in Ukraine. And I think that they're really obsessed with swallowing Ukraine and with restoring the former imperial grandeur of Russia. And therefore, this aggression is not provoked. It is clearly not justified, but this is the conscious and I would say rational decision by Kremlin. So we have to bear it in mind when we are discussing this. Secondly, I would say, and this is my experience of indeed not only the period that you've mentioned, but I was also posted in Moscow before, altogether more than 7 years. I would say that not only we overslept the militarization of Russia, but I think that we also underestimated that the atrocity crimes committed by the Soviet Union in the past, before, during, and after the Second World War were never actually punished. There was never a Nuremberg tribunal for ideology, vicious ideology of communism. There was never a tribunal for Soviet totalitarian crimes. And what we see today is a direct result of this. So impunity in the past is leading to crimes today. This would be my take of what happened. And we really need to stop this vicious circle. And one way to do it is exactly what we are proposing here today. So my third point is that, indeed, and it was mentioned, it's not a Slavonic tribes, fighting for influence somewhere in Eastern Europe. No, it's not. This is about the core of a rule-based international system with the UN at its core. This is about preserving the significance of the UN Charter. And of course, it is also clear that Russian aggression basically erodes the credibility of entire security architecture, that we all, I guess, profited during the relatively long period of time. So if we'll not respond decisively to this in the 21st century, then I would say that sovereignty and equality of each and every state, small and big, is under threat. And this is also why that, in our opinion, that this is UN has to stand behind the Special Tribunal. And in this way, the UN can actually protect itself, its core principles and its charter. And this is also the best assurance, by the way, for countries like mine, which are relatively small, for the future. Fourthly, I would say that also we have to bear it in mind that it's not an abstract crime of aggression. While we are speaking here, people are dying. And these are not only the soldiers. These are civilians who are being killed, some of them raped, it's kids, and so on. So this is really a tragedy that is unfolding at the same time as we are speaking. So, the aggression is essentially, indeed, the mother of all crimes, initial sin, if you wish, and so on. And this leads to this holy trinity: war crimes, atrocity crimes, genocide, and so on. So this is the point here. And of course, it inflicts real human suffering beyond really any imagination if you look what is happening in Ukraine. Finally, from the perspective of my country, and of course I can only speak wearing my national hat here. And my country has been a victim of aggression for more than one totalitarian regime during the last 100 years. So, and having witnessed all the horrors and atrocities similar to what we've seen now unfolding in Ukraine, Bucha, Hostomel, Kharkiv, and so on, we've seen all this. 1940, when thousands of my compatriots were sent to Siberia, we've seen it. This was aggression by Soviet Union against the independent Estonian state. So I would like to say loud and clear that we should not allow Putin and his henchmen, to hide in the judicial loophole that we have at the moment. So we should establish a special tribunal for the crime of aggression by the UN, and by the way, as soon as possible, because people are dying, as I said. So we need to send, and I think this is exactly about the idea whether we should have it or not. But the establishment of a tribunal will send such a strong political signal, not only by the way to Putin, but for all the aggressors of this world. So that's why we really need this. And otherwise, if we'll leave, so to say, prosecution of Troika leadership, Russian leadership, out of this, then it doesn't make any sense, at least to me, and I believe also to many Ukrainian colleagues. So, and this is also a way how the ultimate justice could be served for all the victims, by the way. So also, again, from moral point of view, I think it's the right thing to do. Voila, so the entire world actually is watching. Yeah. So I think that it's great to be here in the company of all those who believe into this, and I hope that together we can push this forward. Thank you very much.
Thank you, Ambassador, for those profound words.
Wow. Well, that was a very powerful presentation. I thank you all, Ambassadors Kornievich, Venevaser, Sheffer, and Tamsar, Professor Trahan, and of course, those were just illuminating presentations. And we're very grateful to our moderator, Professor Hathaway, for so masterfully handling things this evening. I want to thank all of you here in the audience tonight who have come here and for spending part of your evening with us. This presentation has been recorded. It will be on the City Bar website on the Rule of Law Task Force page. You will find there also some materials, including the Just Security blogs that Professor Trahan referenced and some other articles that have been written by our panelists. Please let your colleagues know about the posting and to tune in to this very important program. Really, it's the obligation of us as members of the bar to bring the justice and accountability for the horrors that we have been seeing for the past year in Ukraine. Thank you again, and good night.